In this presentation, I want to go through the theories and the origins of an important yet fairly mystical constitutional concept, that is the rule of law. In the background, you will hear the hardy-does and the rain. But okay, be that as it may, let's carry on. Professor Albert Verne Dicey, who was an influential British constitutional lawyer, or English as he preferred, brought the idea of the rule of law to the fore in the late 1800s. But this idea of rule being constrained by law goes far back, and that is to the Magna Carta in 1215, where the rule of law as a concept was set as the basis of the state. Now, if we try to distill a crisp idea of what the rule of law entails, you will see that it is actually quite challenging, difficult to try and encapsulate this very complex concept in a single definition, since there are many different variants of definitions. But if you have to try and define a purpose of the rule of law, we can say that the idea of the rule of law as a concept is to protect the basic rights of citizens through requiring the government to act in accordance with clear, general, pre-announced rules that are enforced by impartial courts in accordance with fair procedures. So what do we have here? Three components. What is important is the protection of basic rights. What is important is general application, certainty, clarity of the law, the fact that people must know this beforehand, and that the courts that ensure compliance with the laws, that those courts are impartial. The idea thus is, when we broadly speak about the rule of law, is that government may only do that and interact with its citizens in accordance with the rules that are set out in the law, and then also only in accordance with fair procedures. In 1885, Dicey, in his work on British constitutional law, postulated the core of the rule of laws encompassing three aspects. First of all, he said that arbitrary exercise of power, arbitrary exercise of governmental power, is contrary to the rule of law. So in the first instance, the first principle is that no person may be subjected to the arbitrary exercise of power. And the second instance, the second facet, according to him, requires equality before the law. All people, whether you're the king or the stable hand, all people are subject to the provisions of the ordinary law. And then in the last instance, Dicey, and this is typical of the time against the background of the time in which he was writing, he said that the appropriate place for the enforcement of rights that have been given to citizens were in the ordinary courts. And he said all the frivolity and the waste of expenditure on the continent of Europe, where special courts were set up, special tribunals to deal with so-called human rights abuses or human rights aspects, or dealing with constraints on governmental power, according to Dicey, that was not necessary. Now, if we look at this, no arbitrary exercise of power, in other words, the precise contours of power must be set out in law, equality before the law, and protection of rights in impartial courts. Those are not necessarily controversial ideas, but you can see also that those ideas are fairly vague and subject to interpretation. So if we look at simply that no person may be subjected to arbitrary exercise of power, and the law says all Jewish people must live in a camp, well, the law is clear and the discretion is non-existent. All people are subject to the ordinary principles, or the principles of ordinary law, and ordinary courts enforce those laws, or there's some other form of discrimination or unequal treatment, but it is justified, sanctioned by the law that is supposed to protect the rights of people. You can see that this is an imprecise concept that is susceptible to abuse. The actions, for example, of Hitler's Third Reich were backed by the law, and the Nazi state maintained that it adhered to the law. Similarly, the South African apartheid state maintained that it adhered to the rule of law. So, given this background of uncertainty and perhaps some fluidity regarding the concept of the rule of law, Professor Matthews categorized the different theories into 4 sets. And he said, if you look at people's understanding of the rule of law, it is quite evident that some people have a minimalist approach and some people want the rule of law to mean quite a lot. Let's look at these. Now, there's a chapter prescribed in a book for you that I want you to read, and the handout is fairly comprehensive on this as well, but I want you to go and read Matthews and understand what he means when he says that there's confusion and different interpretations regarding the rule of law. And I've plotted on the next slide these on a continuum from being fairly conservative, minimalist, thin, to being all-encompassing, trying to be everything to everyone. In the first instance, there's the law enforcement theory, which is a very thin, basic conceptualization of the rule of law. The idea is if the law backs you up, then there is compliance with the rule of law. So in other words, if the law says discriminates against black people, and I discriminate against black people, I simply go, but the law says that's okay. So that conceptualization, the rule of law, or the law enforcement theory, actually is a rule by law theory, which is very thinnest conceptualization, and it focuses simply on what is backed by law and what is not backed by law. And if your understanding of the rule of law is simply law enforcement theory, then it means that you don't give any normative content or substantive content to particular concepts. You don't set any standards for the content of the law, but you simply ask, did you follow the correct procedures to get to the law and enforce the law? And the hallmark of this theory of the rule of law is legalism. So in other words, if you can simply say that there has been compliance with the rule of law if the law has been followed, but you don't ask any questions about the content of that law, whether fair, unfair, just or unjust. The second theory is the procedural justice theory, and in this theory focus is set on procedures rather than substance. So I don't care what the law says. I simply say, did the law come into existence in accordance with the acceptable procedures? And if so, yes, then there is compliance with the rule of law. I want you to make sure that you understand that each of these are sets of conceptualizations of the rule of law. There are different ways in which people see the rule of law. There are different ways in which states try to justify their actions by saying, I comply with the rule of law. I discriminate against people on the basis of their race, sexual orientation, religion, or whatever the case may be, but I do that because the law says it's okay. That's legalism. The second one, procedural justice theory, is I do that, but I do that because the pedigree of the law, the way in which this discriminatory law came into existence, that is in accordance with our way of making laws, and therefore it is acceptable. Can you see? Those two theories ask, or sets of theories rather, ask no question about the content of laws. And from there we move to a more thicker conceptualization, and that is Dicey theories regarding the rule of law. And in this conceptualization of the rule of law, the only thing content-wise that is required is protection of civil liberties. Civil liberties are first generation blue rights that are rights, political rights, freedom of speech, freedom of movement, the traditional human rights that were first recognized as foundational to an orderly society. So the next thing that I want you to bear in mind, and it will become clearer when we look at the continuum, is that each of these sets of theories encompasses the one or the two above. So the law enforcement theory is necessarily also reflected in the procedural justice theory. The Dicey theory reflects the procedural justice theory and the law enforcement theory plus the requirement that there must be a protection of civil liberties. And then there's the substantive justice theory, which is a conceptualization of the rule of law that requires the achievement of justice in its fullest sense. So according to this conceptualization, and if you look at the article, you will see where it comes from, a committee of jurists who met and said, actually, no one can claim compliance with the rule of law unless they have, in their legal system, they try to protect all rights, irrespective of the nature of that rights, in accordance with fair procedures, backed by law, the whole bang shoot. So it's a quite thick conceptualization of the rule of law as encompassing justice in the fullest sense. So if one adheres to this particular theory or set of theories of the rule of law, you can only claim compliance with the rule of law if you have achieved, or if you are close to achieving, full justice in the polity. I think you can see that this is such a thick conceptualization, such a loaded, packed conceptualization of the rule of law, that one could almost see that it once again becomes as meaningless as the law enforcement theory, which simply says, does law allow for this? And if law allows for this, there is compliance with the rule of law. And I'm going to repeat myself now to some extent by showing you this continuum. The T in this instance stands there, that T, and that one, and that one, and that one, stands for theory, or theories. The law enforcement theory, set of theories. They focus on legalism. So in other words, is it backed by law? We don't ask any questions about where that law comes from, whether it's good, bad, just, or unjust. But if you say, is it backed by law, then you can claim, and you answer yes, then you can claim compliance with the rule of law. So that's a very thin conceptualization of the rule of law. Apologies. The second set of theories is the procedural justice set of theories. And here the issue is, does the pedigree of the law that allows for the action to be taken, is that in compliance with the legal standards set thereof? Therefore, so in other words, you don't look at the content at all, you're not concerned with content, you only look at process. Was there a first reading, second reading, was there a vote, did it pass through Parliament in accordance with clear procedures? And then, if that is the case, then you say, if it infringes upon a right, or limits a right, well, we still comply with the rule of law because our procedures are all in place. Dicey theories focus on civil liberties. So it encompasses legalism, legality, but it seeks to protect civil liberties. And then the last set of theories, the substantive justice set of theories, require compliance or the delivery of justice in the fullest sense in order to comply with the requirements of the rule of law. And if you look at the rule of law as this very complex concept with stretching over very thin to be almost meaningless here, to being very thick and almost meaningless again, you can see that courts have a scope of understanding the rule of law anywhere along this continuum. And what I want us to discuss in class is, when we look at the South African judgments, where are they? Are they here, fairly conservative, or are they there in our conceptualization of the rule of law? Okay. Now that we've discussed these theories, I want to briefly, and I'm not going to spend too much time on this because it's a different conceptualization, but a specific conceptualization and an influential conceptualization of the rule of law, and that is the conceptualization of Lord Bingham. Basically a repetition to some extent of what I've said earlier. Lord Bingham was the Lord Chief Justice of England and Wales, and he delivered a lecture in 2006 which was published in the Cambridge Law Journal of 2007, and is a very useful article in setting out certain pointers by which one can identify whether there's compliance with the rule of law in a particular state. Now, this is a quote from Lord Bingham's article in which he says, the core of the existing principle of the rule of law is that all persons within the state, public or private, should be bound by and entitled to the benefit of laws publicly and prospectively promulgated and publicly administered in the courts. So this for Lord Bingham is the essence. Everyone, there is equality before the law, whether you're public or private. You are bound and you may benefit from the law. That law must be known to you and it must be administered in the public courts. Make sure that you understand all these different terms that are used here. And then Lord Bingham went on to identify 8 sub-rules to the rule of law, and I've highlighted them here, but if you want to know more, I would advise you to go and read the article. First of all, Lord Bingham says that the law must be accessible, intelligible, clear and predictable. So here Lord Bingham says there must be certainty. Certainty to know what does the law require of me. In order for any state to say that there is compliance with the rule of law, Lord Bingham says the law can't be secret. It must be accessible. We must know what is required. How much tax should I pay? How fast may I drive? When should children go to school? Until what age should they go to school? May you homeschool? How long must people work? May they work? So I think the first basic principle of the law, the rule of law, is set out quite soundly here. The second principle, sub-rule, is that questions of legal right and liability must be resolved by the application of law and not through the exercise of discretion. Now, in any modern state, it is sometimes necessary for government officials to exercise discretion. But Lord Bingham says when it comes to determine whether someone is legally entitled or legally obliged, he says don't leave that to discretion. Don't leave that to the Home Affairs official to say, well, I don't like your face, I'm not going to give you a permit. If you are entitled to the right, that must be determined in terms of the law and not through the exercise of discretion. And then in the third instance, and this is not very controversial, I think, that the law must apply equally. And that is simply to say that the rule of law does not condone discrimination on arbitrary grounds. Once again, it goes back to that core issue of a reasonable or a justifiable exercise of power in accordance with clear, just, pre-announced rules. Fourth instance, the law must give adequate protection to human rights. And this builds on the previous one that requires equality. The next principle identified by Lord Bingham is that the legal system must provide for an affordable means of dispute resolution. So in other words, there must be a functioning court system. If you as a state would like to claim compliance with the rule of law, then there must be a court system in which you can resolve your disputes. And then Lord Bingham identifies this as the core, and I think I've alluded to this on a number of occasions. All public officials must exercise their powers reasonably and in good faith and for the purpose for which the power was given. If I was given the power as a police officer to arrest criminals to prevent crime, I cannot arrest people because I'm trying to evade my creditors. I have to exercise the power that was given to me rationally, reasonably, in good faith, and for the purpose for which that power was given. So in other words, what was the reason? What is the power? What was the reason the power was given to me for? And is there a link, a rational connection between the power and the exercise and purpose for which that power was given? The next requirement is that the adjudicative procedures must be fair, and these are the procedures followed in the courts and in tribunals for the resolution of disputes. This requires compliance with the principles of natural justice, such as audi alteram partem, which means hear also the other side, and that there must be an absence of bias on the part of the person making the decision. So, judicial independence. And then Lord Bingham in the last instance says that if a state has undertaken international law obligations, that state can only claim compliance with the rule of law if it complies with its international obligations. Lord Bingham ultimately says that the rule of law depends on an understanding between the citizens and the state, in which they both have to give and take some. And the reason why they give and take is because they ultimately agree that this is in the best interest of the protection of rights. Now, as a general rule, we can say that the rule of law, given that it's such a complex, difficult concept, which requires all of these things, it requires the law to be clear, it requires compliance with international standards, that courts determine disputes, that there must be equality before the law, that there must be protection of human rights, and that there must be rational, reasonable exercise of power with connection between the purpose for which the power was given. So in other words, my police person's example. Then you will see that this is a multifaceted, very complex concept. Therefore, and I'm giving you 3 hooks to try and identify whether there's a breach of the rule of law. And these are illegality. So in other words, when actions are not backed by law. Procedural impropriety. So in other words, we had to go through 3 readings in Parliament, we only did 2. And irrationality. There is no link between my exercise of power, my arrest of the person, and the purpose for which that powers of arrest were given to me. So these are generally ways in which the rule of law can be breached. Now, in our discussion of the rule of law, I want you to focus on the South African case law, how this concept has been developed, and very particularly, where does it fit in here? Does it fit with a very thin conceptualization, or is our court here, where the rule of law means everything, and it's supposed to mean everything for everyone, which makes it a very vague concept to try and apply in a legal setting. Now, perhaps in preparation and going through your readings for class, focus on section 1 of the Constitution that says that the rule of law is a founding value. And try and figure out for yourself in doing these readings, what constraint does it place? Does it require simply that actions, the exercise of power, must be backed by law? Does it require the exercise of power must be backed by law that is supported by appropriate procedures? Does it require the exercise of law in accordance with appropriate procedures, backed by law, protecting civil liberties? Or does it mean full justice? And what constraints the different permutations place on the exercise of governmental power? Thank you.